I am approaching to see if we can amend bond conditions for two cases, actually. One of them is off docket. Is that okay? Can we-
Yes, absolutely.
Okay, I have the case number.
What is it?
It's 254-9067.
Wonk.
Yes,
Okay.
he is here. He had the no contact with the complaining witness restriction and also the address. He lives at the home, he pays the bills. We've spoken with the complaining witness and they said they're okay with no threatening and harassing and allow him to go back home.
Yeah. Sorry, good.
What say you?
Yes, Judge, I confirmed with the complainant, they want him back home and, we just asked that.
My only issue is that he's a prior murder case.
Yes, Judge.
What happened?
This isn't just a court hearing, it's a life in the balance. What would you do if your entire future depended on one moment in front of a judge?
The concern,
I would typically be more.
Whoa, hold up. Did you catch that? The judge is weighing whether to let someone with a prior murder conviction go back to live with the alleged victim in a new case. Legally, this is dicey. Yes, the prior conviction is old, but mixing no contact. Orders with cohabitation? That's a courtroom paradox. Question for you watching. Would you let him move back in if you were the judge? Drop your verdict in the comments.
I think given the age of the murder, as well as the fact that that is his primary residence, I think it might be fair to.
Come up. Wonk. Oh, it's not on document, you said, right?
no, it's not.
So all we're doing is taking off the residential restriction, correct? That's all we're doing? Or there's a no contact order now?
But they live together, so.
Who is the complaining witness in this case?
His girlfriend's son.
Yeah, I mean, we can do,
Have you ripped to see whether the son wants to have contact?
yeah, that's the person that I.
How old is this kid?
He's,
47,
yeah,
Judge.
he was.
Okay, so he's not young. All right. All right. So, Mr. Wonk, they're asking me to amend your bond conditions to allow you to have contact. I will. I'll allow you to go back to this house, but you need to understand there are still conditions of no threatening or harassing behavior. And what you need to understand, what threatening and harassing doesn't matter what you think. I don't care what you think. It's what the other person perceives. So you need to be aware of this. I don't know what kind of relationship you have with the complaining witness, but if it's something where you're constantly butting heads, that could be problematic for you. All he has to do is just call and say, hey man, he's at it again. You're the one that's gonna go back. You understand? Okay, so just be careful. There are many vindictive people in this world. Know who your audience is at all times. So do you mind filing those, no threatening or harassing and no weapons? And then if you don't mind printing out the memo for me, I'll amend it then. Okay, Mr. Wonk, we're gonna need you to sign bond conditions reflecting that you understand everything. Just take a seat. Once we have you sign it, at that point, you're free to go. Okay, thanks.
Judge.
Oh yeah, it's 254-9067. Yeah, okay.
And then I have one other on docket, Hodges. He may not show. We reset him for today to amend the bond conditions, but he's on docket. I can give you the case number off of it.
Yeah, it's not on docket. What's your cost number?
It is 253-2980.
Okay.
Oh, I guess it's filtered.
So this is a failure to give information.
Yes, so at his arraignment setting back in October, you did a no driving, and then we also put a curfew on it. He has been on those conditions since. He's done a defensive driving course. He hasn't had any bond violations or anything within that time.
Is he here?
Yes, sir.
Let's talk facts. Justice isn't always just. Sometimes the system sees your skin color or your income before it sees your truth.
We're just asking, so with the no driving restriction and the curfew.
Does he have insurance as well? Do you have liability insurance in your name?
Car insurance?
In your name. You do have car insurance in your name? As long as you have a Texas driver license and liability insurance, but you have to have it in your name, right? At that point, I'm gonna allow you to drive, but you need to understand that it's a privilege. It's not a right. So if I see you acting a fool in the car, I will take it away again, and I'm not gonna do play this game again. Do you understand? Okay, all right.
Thank you, Judge. And the curfew?
Does he have any other open cases elsewhere
He
too?
does in Galveston,
Do you have over there?
a DWI. However, I mean, he works, he's an electrician, he works 2 hours away. And so the curfew hasn't allowed him to work any overtime or any late nights.
How long do you want? What do you want?
Can we just take it off completely?
Wow, did you hear that shift? The judge is clearly trying to give this guy a break, lifting the curfew so he can work overtime. But then hits him with a brutal warning. This is classic judicial tone shifting, empathy wrapped in a grenade. This moment is crucial. It's the system giving a second chance, but dangling it by a thread. Let's see if he keeps it together.
I mean, he's been on it since October and he's shown that he can be consistent and that he wouldn't have any trouble. Looking at it now, I think he deserves a second chance.
Okay, we'll see. If you pick up a third case, I'm gonna absolutely lose it. Do you understand? Make good decisions. We're not asking for much. You endanger my public. I'm gonna go nuts on your bond. Do you understand? Okay, all right, we'll give you a chance.
Judge, we're removing the DPS from 55.
Correct. All right, Mr. Bonds. Hey,
Mr. Proctor, again on the docket
Okay.
for, he's got a
you leave back there. Okay.
revoted bond on his terroristic threat, raise it to 7. Would you lower it to 5,000?
Yes.
Okay.
Yeah.
And then,
So hold on a second.
conditions,
What's it now? It's at.
7,000.
So what I'll do is. $5,001.
Okay. And then conditions on the DWI.
Just standard conditions. I mean, does he have any other? Do you know if he has any other DWIs?
No, I don't think so.
No, Your Honor.
Okay, so just no alcohol, no dope, no weapons, no contact with the complaining witness in the terroristic threat. Just standard bond conditions, but let him know if he picks up a third case, all bets off. Right? And then, Mr. Pons, I just sent you an email.
Yeah.
So-
I was going to ask you, because I did a lot of work to not work that Monday. That's Super Bowl Monday.
You want the next day?
Yes. Okay.
Absolutely.
I'll see you Tuesday then.
Yeah.
Thank you. All right, man.
I'll let Victoria know. Mike, yes.
How are you?
What's going on with you, man?
Here on Mr. Matthew Adolph. The state has just filed a nollie on that case.
Okay,
He's on his way back from,
I'll sign it. I mean, if they're dismissing it today, then there's no need to address anything. You know?
he's on the way back from the VPR. That's passed, so it's a moot point. So
right.
it should be in your queue.
Okay, I'll send it right now.
All right, thank you, Judge.
You got it.
May I be excused?
Yes, sir.
God
Thanks.
bless.
Hi, Sean, how are you, man? If you want a copy of the nollie, we can give it to you now. I'm signing it now. Okay. Hi, Sean.
I have one. It's the top of page 12, just trying to avoid using the name with it.
Okay. What do you want to do?
So we are working with felony right now, kind of going up the ladder at the DA's office about possibility of a diversion for upstairs that will, I believe, work this one out. Chris went upstairs and talked.
You representing him upstairs?
Yeah, yes, sir. Here and
Yeah, we're co-counseled on both of them.
Okay, great.
We feel optimistic about it, but we just haven't gotten a full answer since there's been a change in administration and all that. So everybody. can
So
tell-
did he have a PTI in the first? Is that why?
This is the evading that he's charged with. I have my own serious doubts about, but I think in his interest, he's trying to seek it.
Now that's rare. A judge who doesn't just see a file but sees a future. This is where second chances begin, or end.
But the problem is that it's old.
Yeah.
So how long do you want? I mean, we got to set a time. I got to give you a time limit, right? It's 220 days now.
And can we go about 30 days?
At that point, I don't care. I'm going to set you for trial though.
Okay.
Like you're out of time at that time. You're at 250 days and that, it's just too much, right? So I will give that to you, but that's the last setting.
Okay.
Okay? So do what you can to try to work it out as fast as you can, but that's it.
Okay.
Discovery's complete, right?
No, we are missing the search warrant and search warrant affidavit.
And then I'm going to have a big problem with this. And then I'm going to set this for if you guys are missing something at 220 days, Alex, I'm going to have a big problem with this.
Judge, just let me confirm.
Okay.
Regardless, your cutoff day with this case is 250 days. So what I'm going to do is I'm going to set this, if you're truly lacking something, I'm setting this for discovery hearing. And if you don't get it within that time, that's it.
Yes, Judge, it appears we're still missing the warrant, so we'll reach out immediately if we can get it.
Setting it for a 10-day discovery hearing.
Hey, discovery hearing.
You don't have absolutely everything.
Yes,
it's
Judge.
not going to go well for you.
Yes, Judge.
It's unacceptable that at 220 days you're still missing a warrant.
At that 10-day hearing, will his appearance be required or will be waived?
You can be waived. It's not a big deal. So we're on top of page 12. They're still missing a discovery. So I'm setting it for a 10-day discovery hearing. What I would do is I would subpoena the officer to come to court.
Yes, Judge.
Deuces Teakum.
And we'll have them, but we'll
Yeah.
find it your own.
So set it for 10 days, but the cutoff with this case, regardless, is 250 days. At that point, it's clear trial. So, okay, guys, see you in 10 days.
Thank you.
Thank you.
Oh, and hey, Judge.
Hi, Marcos.
Got a plea, Mr. Gonzalez Hernandez.
Okay. You ready?
I call him up.
Please.
Do you have the cause number?
Yes, thank you.
Our friend, Mr. Martinez, has not made it up, so hopefully he'll come up tomorrow, Judge.
Say it
Our
again.
guy from yesterday.
Are you posting bond?
I don't think he's posted bond. No, I don't see an ISO, so I guess we'll see.
Really? No one's gonna post it for him? No one's gonna post it?
I don't know yet.
Por favor, conteste a voz alta.
Good morning, Mr. Gonzalez
Buenos días,
Hernandez.
González Hernández. Good morning.
Are charged with driving while intoxicated. First offense, it's elevated to a Class A misdemeanor because of the high blow. So you are facing up to a year in jail and or a $4,000 fine.
Multa de $4,000.
You guys have worked out an agreement. They're offering you 1 year in Harris County Jail.
Año en la cárcel
For that to be probated for 15 months.
de meses.
Is this a second or a
Es la
first?
segunda y
True
la primera.
first?
True first.
La primera.
As part of the agreement for you to successfully complete this, you must do a DWI education class.
Base de
You must do a victim impact panel.
tener un panel de
You must also do a TRAS. This is an evaluation to see what other conditions you may need.
condiciones
If
necesarias.
they assess other conditions, you must fulfill these conditions as well.
Tener
Substance abuse treatment,
también. Eso incluye tratamiento.
no breath test refusal,
Pero,
meaning that if you're pulled over while driving a car and an officer asks you to submit a breath sample, you must do it.
aliento-
No drugs, alcohol. You must have a guardian interlock and 30 hours
20
of
horas.
community service. Does he have a Texas driver license?
He
de
does not
licencia
drive.
de
You are
manejar.
not allowed to drive. I want you to understand I take this absolutely serious and you will be signing a promise with me today as part of your probation that you're not going to drive.
Como parte de
There's
su
nothing worse than
You serve your time, but the world never forgets. The real punishment being shut out, Evan, when you've changed.
alcohol or driving. Those things will land you in custody faster than anything else.
rápido.
And if you're not in this country with permission, and you go back to jail, it may be your very well last time that you
Última vez.
are here. Do you understand?
Entiendo. I do.
You're giving up the right to a trial, right
Derecho
to
al juicio.
compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible
Ciudadano.
immigration
Hay
consequences. You can
posibles
be deported,
consecuencias migratorias.
excluded from the country, denied naturalization under federal law. You give up the right to appeal.
Su
Once you
derecho a
plead guilty to this offense, it will go on your record. You will never be able to take it off.
sacarlo.
Do you understand?
Entiende.
You also need to understand that if you
Entienden
get pulled
que-
over in the future, you're in a car driving,
Ando.
an officer, the first thing they do is they look at your driving record. If they see a prior DWI and they come up to your window and they smell alcohol or they smell something funky, it's not going to go well for you. And from now on, you are facing a minimum of 90 days in jail for any new cases that you pick up.
En caso nuevo que usted le da.
You understand?
Entiende. I do.
All right. How do you plead to the offense? Guilty or not guilty?
Guilty.
I will find you guilty, send you to the agreement. Good luck to you, sir.
This is the part where it gets real. That $3,500 surcharge? Waived. But only this once. Harris County doesn't play around with DWIs, and this judge is making it crystal clear you mess up again, it's not just about jail time, it could cost you your entire future. Quick thought, should Texas rethink these massive DWI surcharges, or are they justified? Let us know what you think.
Buena suerte, señor.
Thank you, Judge.
The fee. The fee.
Wait, the thing, okay, is it?
So, hold on, Tony. I need you to tell him one more thing. I want you to understand something.
Usted entienda
That DWI is extremely big business in Harris County and in Texas. There is a $3,500 surcharge that typically would apply to you on these types of cases. I will waive it for you now because it is a first offense. On a second DWI offense, it is a $6,000 surcharge, and if you don't pay it, you do a ton of jail time. Do you understand? So get a clue. If you want to drink, don't get into a car.
Metan un carro.
All
Thank
right.
you, Judge. Appreciate it.
Ready?
Yes.
Wait.
Your Honor, it's actually off docket and it's just for bond conditions. We were here last week on the Devontae Levi. You want to
Okay.
give number?
Yeah, sure.
254-8452. So you were going to bonds, we're doing a new one. You ordered bond conditions, but they were not entered. So we're back again.
So let's enter it now, and we can have him sign it, and that way we're.
Okay, well,
If Samir was your son, your student, your neighbor, would you still see a criminal lawyer, someone worth saving?
so if you could please order them again.
Remind me what happened again, Alex, please, if you don't mind.
One moment. Pulling it up. Let's see.
And I talked to Mackenzie, Gary. The judge wants a reminder.
Oh, it's 254. Fine. Yeah.
He's still in custody, right?
No, Your Honor, he's on bond.
Was he here?
Yes, Hodges, please.
So, come up, Mr. Levi. Or is it Levy or Levi?
Is it Levy or Levi? Levy, Your Honor.
Okay. Mackenzie, do you mind?
Yes, so on January 21st, 2025, an officer made contact with the complainant. The complainant stated the defendant, she knew him from a previous dating relationship. The complainant stated she ended her relationship after finding out she was 6 weeks pregnant and was paying the defendant's phone line until she turned it off on the 21st of 2025. And the defendant started sending her threatening messages on the 16th, 2025, stating that he was going to make somebody jump on you and knock your teeth out, and delusional hoes like you deserve to die. The complainant stated she went to turn off the defendant's phone line on the 18th, and the defendant is now using Wi-Fi to continuously threaten and harass, with the last message on the 21st of 2025. The complainant is in fear for her life, and the defendant was ID'd by his Tennessee driver's license.
Got it. Okay. So he's also on probation. Are you representing him on his probation case upstairs?
That was terminated, Your Honor. It was early terminated.
So he's not on probation now?
No,
So, Mr. Levi, or Levy, I'm ordering you not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, I will put you back in jail. Do you understand? You're not to have any contact with the complaining witness in this case, and you're not to be in possession of weapons as well. Did we do a,
there's a
Moab?
motive. It has not been signed, Your Honor. It's in the system, but it was not signed.
Right, so I'm entering now what's called a mattress order for emergency protection that identifies Miss Beck as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot go within 200 feet of where she lives or where she works. Do you understand? If you violate this court order, the state can and will file a violation of protective order against you, and that is the capital murder of misdemeanors. You pick up a case like that, it's really going to go sideways quick. stay away and control the temper. Because if you become a danger to my community, I'm gonna unleash on you. Do you understand? I don't care who you are, I don't care where you're from, but I'm gonna protect my community at all costs. We will have you sign the order for protection. I'll have you meet with Fleischer for bond conditions, and after that, you guys are free to go.